Well, Carlos, it is great to be with you today. How are you doing?
I'm doing well. Thanks for having me. Good morning.
Yeah, absolutely. Well, I'm looking forward to our conversation today. I know we've got a lot of stuff that we want to cover, and we're going to be specifically looking at work permits. But I want to just maybe take a step back before we dive into that and start with kind of all of the different channels that are available for people to legalize their status in the US. So, can you share just a bit about that to kind of give us a perspective of how broad this topic can be?
Sure. So it is very broad. Thanks for the question. I mean, there are two primary ways in most cases for an individual to become a lawful permanent resident. One and most common is a family petition, and there are different categories available in order to request your legal residence through a family member. Not every family member is able to file a petition on your behalf, or on behalf of that individual, but the categories are broad, and mainly they include petitions through spouses, sons and daughters, even siblings are able to file petitions on behalf of their family members. Another significant category are employment-based petitions, where an employer is able to file a petition on behalf of a future prospective employee in order for that employee or future employee to also become a lawful permanent resident. Once we leave the area of family law immigration and employment law immigration, of course, political asylum is something that comes to mind. A program called cancellation of removal based on your lengthy presence in the U.S. is certainly another way to do that. And there's finally something called the U visa process for the victims of crimes, usually violent offenses, who have cooperated with law enforcement, where given that cooperation after the individual is a victim, that person qualifies for employment authorization, which eventually and in turn will turn into lawful permanent residence. But it's important to note that for the U visa process, not every crime is going to qualify the individual for U visa status. It's really important to understand that the crime has to be a specific type of offense in order for immigration to consider that application. There are, of course, other ways to apply for permanent residence, but in my mind, these would be the five primary applications that we would consider in assessing someone's eligibility for that legal status.
Yeah, thank you so much for walking us through that. This is a broad topic, so I'm excited to unpack it a little bit today and in future episodes. As we look at this work permit concept and everything that goes into it, I know there's a lot of misinformation out there around work permits. Can you take just a moment to address some of that misinformation before we get into some of the questions that we have planned for today?
Certainly, I think that one of the traps, in my opinion, for many folks is applying for a work permit, not really understanding the consequences of that employment authorization card the individual is going to be issued. There's a lot of room for fraud when you apply for a work permit, and I would caution anyone looking for a work permit to be extremely vigilant and extremely careful, because the question has to be, what is the underlying application that allows me to apply for that work permit? And I'll tell you an area that concerns me greatly. An application, for example, for political asylum is one that is often used by many lawyers and notary publics who practice in this area in order to apply and obtain work permits for individuals in the U.S. who are here illegally. Anyone can file the I-589 application, and once you file that application, 180 days after you file the application, the Immigration Service will issue you an employment authorization card. You will be fingerprinted, and you will be entitled to apply for employment authorization. Currently, that work permit is a work permit that is issued to you for 5 years, given the delay from the moment you file the application to the moment that you actually see an immigration officer or eventually see an immigration judge. But the problem with political asylum is that, unfortunately, most people, the vast majority of people, do not qualify for political asylum. And they do not qualify for political asylum for a multitude of reasons. One, in order to file for asylum, you must file for asylum within 1 year of your arrival in the United States. So if you've been here now for more than 1 year, that application is going to be considered late. It's a late application for asylum, and that on its own is going to make that application much weaker. And the other problem with asylum is that in order to qualify for asylum, to obtain that relief, You have to show that you were the victim of past persecution or that you have a well-founded fear of future persecution based on one of 5 reasons. And these are the only reasons that you can offer to apply for asylum. Reason number 1, that you are the victim of persecution or possible persecution because of your race, because of your nationality, your religion, political opinion, or membership in a particular social group. These are very limited categories in order to apply for and obtain political asylum. This is the reason why these cases are often denied, particularly for Latin America, because Latin Americans, for the most part, not everyone, but for the most part, are not being persecuted in their native country because of their race, nationality, religion, political opinion, or membership in a particular social group. And so given that these are the only 5 areas that allow you to obtain political asylum, you got to be very wary of that and understand that general violence is not enough to apply for asylum. Extortion is not enough to qualify for political asylum. Recruitment by gang members is not enough. General criminal threats are not enough. It is extremely difficult to win a political asylum case for most individuals from Latin America. And so I always tell people with a great deal of caution that they really have to consider whether they want to file an application that may lead to your deportation. Because once you get that work permit and once you're fingerprinted and you are in that process, there is no way of stopping it in most cases. There are some ways to have that case dismissed, but in most cases, once you start that asylum process, that case will eventually end up in immigration court, where that judge will order your deportation, your removal from the United States, in most cases, where an appeal to the Board of Immigration Appeals is going to be dismissed. And again, and where another appeal to the Ninth Circuit, in most cases, again, will also be dismissed. And ultimately, you're going to be issued a removal order. ICE eventually will come look for you. And eventually you will be taken into custody and deported from the United States. And even if you have a clean record, you're working, you have family, you're paying your taxes, you're a great individual, an asset to the community. Once you lose that political asylum case and you are ordered removed, it's just a matter of time before immigration comes and executes that order. So again, be very careful with that work permit that you obtain under that political asylum process.
Wow. Yeah, that's scary stuff. So thanks for taking a minute to kind of clear that up. And if people are getting the wrong information, definitely book a consultation, right? Get the right information. May not always be the easy answer, but it's going to get you the right result, right? So absolutely. Okay. Well, hey, let's dive into work permits. I guess let's start with, are there different kinds of permits available? And if so, can you kind of walk us through them?
Well, sure. I mean, there are different. Well, the work permits look exactly the same. It's an employment authorization card. The only thing that is different are the categories that allow for these employment authorization cards. For example, the political asylum work permit is a CO8 category. So if you have a work permit and you look at it and you'll see that says category CO8, that is a political asylum work permit. Other categories are C10. C10s are for individuals in immigration court proceedings who are applying based on their presence in the United States. The application is known as cancellation of removal, and that's a C10 work permit. Other work permits, for example, are under the Deferred Action Program, the DACA program for Dreamers. That's a different category. Others qualify under a program called TPS, Temporary Protected Status. But what's important, I think, to bear in mind here with the work permits is that these work permits are obviously temporary. Most are renewed every 2 years. As of last year, work permits now being issued in some categories for 5 years. But the goal here is not just a temporary work permit. If the work permit is what you're looking for, unfortunately, with that perspective, you're going to make mistakes and you're not going to take advantage of other opportunities that may be available to you. And I'll use DACA as an example. DACA gives you employment authorization, certainly, but it also allows you to apply for a travel document called advanced parole. Advanced parole allows you to go back to your country and return legally. You are, quote, paroled into the U.S. It is a lawful entry in the U.S. Now, most people, unfortunately, under DACA, were brought here as children illegally without a visa. And when you were brought here illegally or you come here illegally, you are at the bottom of the immigration barrel when it comes to many immigration benefits. Once you travel with that travel document, the advance parole, in essence, what we're doing and what you're doing is you are cleaning the illegal entry from when you were first brought to the US. Once you clean that illegal entry, you elevate your immigration standing, which may then allow you to apply for legal residence with the interview inside the United States if you file a petition through a US citizen spouse or a US citizen son or daughter over the age of 21. The TPS program for temporary protected status, mainly for El Salvador, Honduras, and other countries, again has that benefit of not just receiving a work permit, but the opportunity to travel to your country to visit, it's a sick family member. And when you return from that trip, after cleaning the illegal entry, you will then be able to qualify for your legal residence and the interview for legal residence in the US if you have a petition available to do so without having to go back to your country for an interview at the US consulate office.
Okay, awesome. Yeah, thanks for walking us through some of those different eligibility criteria. And as you're kind of talking through that, man, I'm seeing that there's a lot of challenges or obstacles that individuals might face when applying for a work permit. So, there are any other challenges that you come across as you're working with your clients that you want to share, kind of as a cautionary tale, so to speak, for people that are seeking that resident status?
Sure. So my word of caution to everyone in a case involving immigration law is do not be fooled, right, by the value of that work permit. I know you want a work permit. I know you want a social security number, but if the price you're going to pay for that work permit is your eventual deportation and removal from the US, it doesn't make any legal or common sense to do that. I think it's important to make sure that the kind of work permit you have doesn't have that risk of removal and deportation. Certainly, I agree and I will accept that. Every process, every application has a risk factor, but you don't want to expose yourself to deportation just for the sake of obtaining a temporary work permit. But speaking of work permits, a work permit that comes to mind that will allow you to obtain a work permit safely and then eventually qualify for legal residence is the work permit under the U visa program. The U visa says that if you have been the victim of certain crimes, usually violent crimes, and you have reported those crimes to law enforcement, that because of that cooperation with law enforcement, you are going to qualify potentially for a U visa. That process begins with a police report. Certainly, we look at the police report to make sure that you have been the victim of a qualifying offense. If we believe that you are the victim of a qualifying offense, we request certification from that police department that took the report, the police department, or even the DA's office in some cases. And the police is going to sign a form certifying that you are in fact eligible to apply for that U visa status because you were the victim of a qualifying crime and because you cooperated with law enforcement. Now, it doesn't matter that the accused or the defendant was apprehended, convicted, or even sentenced, or that you were even able to identify the individual that assaulted you. As long as you were the victim of a qualifying crime and law enforcement is satisfied that you cooperated to the extent that you could cooperate, law enforcement is going to sign that certification of your eligibility. Once you have that certification, you then file an application for U visa benefits along with a 212D3 waiver application. The waiver under the U visa process is for your unlawful presence in the US, any prior criminal convictions that you yourself may have that may render you inadmissible to the United States, and any other immigration violations that could potentially pose a problem. The U visa is safe and it's very effective. The problem with the U visa, and here's something that has to be that you got to bear in mind, is that there is a lengthy waiting period. Most individuals are waiting approximately 4.5 to 5 years, 4.5 to 5 years before you receive that 4-year work permit, temporary work permit under the U visa program. The actual approval notice and the waiver that accompanies the U visa is taking approximately 7 to 7.5 years right now. Now, in some cases, I will tell you that the temporary work permit is issued way before the 4.5 years. I have clients who have received them in 6 months, in a year and a half, 2 years, but those are the exceptions. And it's by random luck. It's almost like a lottery that immigration plays with these cases at times. And yes, some temporary work permits will be issued under the U visa process before that 4.5 year to 5 year mark. But in most cases, you're going to wait that long to get that work permit. Yes, it takes patience. Yes, you have to wait a long time, but it's extremely safe because it does not involve going into immigration court proceedings like a political asylum case. Under asylum, you get the work permit right away, but the consequences will be dire in about 5 years once your case is processed and adjudicated. On the other hand, under the U visa program, you're going to wait that long, 5 years, without employment authorization in most cases. But at the end of that road, you're going to get a work permit that is safe that will eventually then allow you to become and apply for lawful permanent resident status.
Awesome. Yeah, that's great insight. And it's as you're talking through that, I'm thinking of these challenges, some of the obstacles that people face. Is there anything that people can do proactively to help avoid challenges or obstacles with that work permit process?
Sure. So, number one, I would tell you do not visit notary publics for assistance with your immigration case. I know they may speak Spanish better than we do in my office. I know that they may be a lot less expensive, more accessible, closer to where you live, but notary publics are not licensed, and they are obviously more willing to take chances because they have nothing to lose. There is no license issued by the state bar. For example, of California, there are no real consequences. The DA's office in Los Angeles has investigated and prosecuted many individuals that provide immigration advice, that provide legal services in a way that should be done by filing applications for which individuals eventually are going to be severely harmed. So one word of advice here is do not go to a notary public for legal advice, especially in the area of immigration law. And make sure you have a referral, that someone obviously refers you to the lawyer that you're going to visit, that the person is reputable. You can look up their license. You can look up their history with the California State Bar, whatever state bar they belong to. I think it's important to make sure that the individual that you're going to has experience and is going to speak to you with the truth. Above all else, that he or she is going to be truthful in his or her assessment of your eligibility for a work permit or, better yet, lawful permanent residence.
Awesome. Thank you. I'm thinking, as we're talking work permits, is there a difference in process for getting a work permit if it's an employee versus an entrepreneur or freelancer? Like, how does that work based on those different employment categories?
Sure. So obviously, there are different categories. Just like with family petitions, we have first preference all the way to fourth preference. In the employment context, there are also categories. The problem is this: most employers, many employers, are willing to help their employees. Many employees who already work for these companies and are working, let's be frank, illegally without proper authorization. But the law says that once you have overstayed your initial visa, once you are considered to be residing in this country illegally, you are not eligible to apply for your legal residence inside the United States, even if the employer is willing to sponsor you. So, in most cases where the individual has fallen out of status or is here illegally, that person, to become a legal resident, has to go back to his or her country for that final interview in order to obtain that legal resident status. But the law says this, that if you've been here illegally for more than 1 year and you have to leave the US to go back to your country for an interview at the US consulate, you will be barred for 10 years from coming back to the United States. And so even though an employer may be willing to help, an employer may have the financial ability to satisfy all of the requirements that are needed to satisfy this particular type of case. Even if the individual has all the experience, is a vital person to the employer. If you have to leave the US for that interview in order to complete that process, that is not a case that you're going to pursue. And you're not going to pursue it because you're not going to leave for 10 years. The employer is not going to wait for you for 10 years. And so, although the process does exist, clearly it does exist, it is not really an option for people that are here illegally. Now, for those that are here legally, as students, and possibly in other categories, the employment-based process is a very legitimate way of applying for and becoming a lawful permanent resident. And so from the very beginning, right, a disqualifying factor in assessing your eligibility is going to be whether you are in status whether you're out of status when it comes to an employment-based petition. If you are out of status, there really is no real choice through the employment-based petitions to qualify you for legal residence. But if you are in status and you've been able to preserve that status, the employment-based categories may certainly be useful to you in assessing your eligibility and applying for legal resident status in the United States.
Awesome. And interesting you're talking about student work. I am curious if somebody's here and they're going to school and then they want to work here, how does that process work?
Sure. So you enter the country as an F1, and most people, after they complete their studies, qualify for 1 year employment under an OPT program. But if you want to remain in the U.S. after you complete your studies, you need a U.S. company. Again, in most cases, there are some that can self-sponsor themselves, but in most cases, you need an employer, a company who's going to offer you a job, who's going to offer you a position. And through that job offer, you are going to qualify for a work permit and eventually lawful permanent residence. But of course, it requires that sponsor. It requires that employer who is willing to help you legalize your status in the United States. There are national interest visa waivers that are also available, given your particular experience, education, and success in your field. But I would say that most cases require an employer and a job offer through that U.S. employer in order to obtain legal residence through these employment-based categories.
Great to know. Thanks for sharing that. Are there any specific industries or professions that have different requirements or considerations when it comes to obtaining a work permit?
Well, certainly, even within the context of employment-based petitions, we have first preference, second preference, third preference, other workers, religious workers. And so it really turns on your experience and your level of education. Now, it's important to make sure that your education experience satisfy the requirements for the jobs that are being offered. Some employers try to help you and they try to draft positions based on your experience and based on your education. And you have to be careful with that. In my opinion, there has to be a significant connection, a nexus between your education and experience and the nature of the employer's business. But yes, there are different categories, and it really does turn, in many cases, on your level of education and experience. And of course, also the nature of the business that is making that job offer.
Awesome. Thank you. You've mentioned a few times that work permits do eventually expire or renew, which certainly there are other options to try to legalize permanent residency. But as we look at specifically work permits expiring or renewal, can you walk us through that process and what does that look like for somebody that has a work permit that is expiring?
Sure. So usually work permits are going to be issued for 2 years, in some cases 1 year, and right now for 5 years. So before that work permit expires, usually within 90 to 150 days, you're going to file the I-765 application asking for that employment document to be extended. Now, during COVID, immigration experienced some significant delays in processing these renewals. And so the administration has issued memorandums on being able to use these expired work permits once you file for a renewal of that application or that employment authorization, as long as the underlying application, the basis for your work permit remains valid, as long as the case is pending, as long as the case is viable, you're going to be able to renew your employment authorization. For example, if you file for lawful permanent residence and you qualify for legal residence, for the interview for legal residence inside the United States, you're going to get a work permit and you're going to be able to renew that work permit until eventually you become a lawful permanent resident. In the past, these work permits were issued for 2 years. Now they're being issued for 5 years because of the delays that we continue to confront after COVID. But again, renewing a work permit is a simple task as long as your application for legal residence is open, as long as you remain eligible for whatever benefit you're seeking, whether it's as a childhood arrival, DACA, TPS, or because you have an adjustment application pending, as long as your status remains pending and you're eligible for that benefit, renewing a work permit is not complicated. It's quite simple.
Okay, and then final question as we wrap up here. What options do individuals have if the work permit is denied?
So you can always file a motion to reopen a work permit. The I-290B form is the one that is offered to individuals whose work permits have been denied. But in many cases, the sad reality is that once the work permit renewal is denied, it's because the application for legal residence has also been denied, or because you have lost eligibility to renew that work permit. For DACA recipients, for example, if you commit a serious misdemeanor, you commit a crime, if you are arrested, for example, for driving under the influence of alcohol, you're not going to be able to renew your DACA work permit. In the past, if we could get that DUI conviction expunged after you had satisfied probation, DACA allowed you to renew that work permit once that DUI was expunged. But right now, immigration is having issues with the DACA renewals because there was a stay issued by a court in Texas for new applicants or for individuals that did not renew their DACA work permits in a timely fashion. And so, unfortunately, if the work permit has been denied, there's a bigger problem because that means that you are no longer eligible for the benefit that gave you the right to apply for that work permit, or the primary principal application that you had filed for legal residence has also been denied, or because your asylum case has been completed and the court has issued a removal order and you are now subject to removal from the United States and therefore no longer eligible for employment authorization. So in those cases, I would look for the underlying problem to explain or understand why the work permit was denied. The work permit is simply a benefit that you receive while your other application, in most cases, is still pending.
Well, again, wonderful information. Thank you. And thank you for your time, all the insights today. For those that are watching, if you're interested in learning more about work permits or any of the other immigration services offered by Carlos Cruz Law, definitely head over to carloscruzlaw.com. Book that consultation to make sure you're getting the right information and help you achieve whatever your immigration goals are and ultimately that legal permanent resident status. So, Carlos, thanks again. Really appreciated it.
All right, thank you. It's been a pleasure.